Today we're very honored and it's a pleasure to have one of our own, our treasurer, Carol Sales. And we're going to be talking about bankruptcy law. And I should mention I am the host, Justice Jesse Reyes, current president of the Diversity Scholarship Foundation. Welcome, Carol.
Thank you very much. Thanks for having me today. I'm excited to be here.
It's our pleasure.
So just to start off, I wanted to mention something about the foundation and the work it does. So the purpose of the foundation is to raise scholarship funds for law students and potential attorneys and even some college students as they're preparing to enter law school. And the other component of what the foundation does is that it raises funds and supports other organizations in the legal community. And so we do that with the support of law firms and attorneys, and we have our big event every year called the Unity Gala.
Thank you, Carol. So tell our viewers a little bit about yourself, where you grew up or where you went to school.
So I grew up in Park Ridge, Illinois. My parents were from the Philippines, so I spent my whole childhood in Park Ridge, and then as an adult, I moved back there. I work at Robbins DeMonte, and it's a law firm with offices in Park Ridge and Chicago. My husband also works at Robbins DeMonte. So for the past 18 years, I've been an attorney, and I've practiced in the fields of commercial litigation and bankruptcies.
Okay. Then with regards to the topic that we want to discuss today, which is bankruptcy, I know there's various viewers out there that some may know about bankruptcy, some of them may not. So you could describe the various common categories of bankruptcy there are? There's Chapter 9, Chapter 11, Chapter 13, and Chapter 7, correct?
Right. So the main chapters that I guess viewers probably want to hear about would be Chapters 7s, 11s, and 13s. So Chapter 7s, the goal of a 7 is to obtain a fresh start. Basically, it's a liquidation, and Chapter 7s can be filed by individuals and organizations. So on the date that a Chapter 7 is filed, everything that, let's say it's an individual, everything that the individual owns becomes property of the Chapter 7 estate. There's a Chapter 7 trustee whose job it is to administer all of the assets for the benefit of the unsecured creditors. So if there are any assets in the estate that are not encumbered, or to the extent that there's anything left for unsecured creditors, then the Chapter 7 trustee would sell that. But by that same token, the individual debtors, they have certain exemptions under state law. So in Illinois, for example, if you file a Chapter 7, you're still allowed to keep your IRAs, 401ks, the cash surrender of life insurance policies if your spouse or dependent beneficiary or a dependent are the beneficiaries. There's a $4,000 wild card exemption, $15,000 of equity in your home, and all that sort of thing.
So I have a question. So an individual wants to make a decision to file bankruptcy under Chapter 7. So first of all, how would you come to that decision, and then how would you proceed? I mean, do you go actually in person now to court and file a petition for bankruptcy, or can you do it online, or how would someone proceed, first of all, in making the decision they're going to want to go and file bankruptcy?
So usually by the time it gets to that, there's a lot of stress, there are a lot of negative things financially happening in the person's life, and usually bankruptcy is the last resort. So in 2005, the bankruptcy code changed where an individual debtor has to take a credit counseling class. So that's one requirement. They have to take the class. They can do it online or over the phone. The petition and all of the schedules and related documents that you file are filed electronically. If you have an attorney, attorneys are required to file everything electronically. So what the debtor needs to do is disclose all of the assets, income, and certain transactions that have happened. So it's really something that people don't take lightly because you can't file Chapter 7 every 8 years. And so, like I said, the goal is to obtain a fresh start. There are certain debts, though, that would not be dischargeable. For example, let's say somebody defrauded another person, or there's something called willful and malicious injury to property, or if someone let's say, were to submit a false financial statement, certain things like that, or even, certain tax liabilities and domestic support obligations, certain things are not dischargeable, but a lot of things like credit card debt, mortgages, other consumer debt, medical bills, things you've guaranteed, those would be discharged.
So if you have a mortgage on a house, and let's say you have a car loan, and you're going to file bankruptcy, are you going to lose your house and your vehicle?
Possibly. So let's say you file a Chapter 7 and you have a lot of equity in the house and equity in the car. Then yes, a Chapter 7 trustee would want to sell those two things. So then you mentioned the different chapters of bankruptcy. That's a good segue into chapters 13s and 11s. In 13s, it's a reorganization, and you pay a Chapter 13 trustee from either 3 to 5 years into the plan, and through the plan, your creditors receive certain distributions.
And is an individual person capable of being under 13?
Yes, so individuals file 13s, and then individuals can also file 11s, and then entities could also file 11s. So if you are over the debt limits for 13, then you can file a Chapter 11. And the government has, according to its public policy, they encourage basically Chapter 11 and 13 as opposed to a Chapter 7. And so in an 11, it's the same thing. It's really a plan of reorganization, or in a Chapter 11, you could do a liquidation too. So in an 11, let's say you're an individual or a business, you file a Chapter 11 and you file a plan, and the plan says these are how creditors are going to be paid according to priority. So the one big thing that happened in the bankruptcy world was in 2019, the Small Business Reorganization Act. It created Subchapter 5, which is a subchapter of Chapter 11, and right now the debt limit is $7.5 million. So if you're under that, then you can file a Subchapter 5 case, which is basically an easier way to reorganize.
So let's say, for example, you have children that are in school, and you're paying tuition. Does the filing a 7 or a 13 impact you in that regard?
If you're paying, so are you saying that
if your children are in private school, and you're paying tuition to the school?
Oh, so let's say you're in a Chapter 13, that could be problematic because some parties and interests might not be happy with certain expenditures. We see that sometimes in Chapter 11s too, where the person's lifestyle might be an issue, because if you're paying a certain amount to towards your plan and to creditors, then how much are you paying towards your lifestyle? And it's sometimes frowned upon if you have a lot of expenditures in that regard. And also, let's say your kids are in college or they're over 18, and maybe you're not obligated to provide for them if it's not in judgment for dissolution of marriage or certain other things. So that's when someone's lifestyle does come into play.
Okay. And so let's say you file a Chapter 7 or a 13, you're an individual. How long does it take to work through that whole process?
So it really depends on, I know that's not a good answer, but it depends. You can have a Chapter 7 case that lasts several years. So within a Chapter 7, there can be adversary proceedings. So it's a lawsuit within the Chapter 7. And those lawsuits could be about whether the individual is entitled to a discharge, whether certain debts should be discharged. In a Chapter 7, a trustee could also take a while or maybe even a few years to pursue certain claims or liquidate certain property. But if it's a relatively easy case, then just a few months should be okay. But then in a Chapter 13, as I mentioned, the payment plan in a Chapter 13, those are for either 3 to 5 years, but it can't last more than 5 years. And then the number of years depends on the income level.
Well, let's say you're not done in the 5 years, then what happens? Do you have to refile again?
So if your Chapter 13 case, let's say it doesn't conclude within the 60 months, then it could be dismissed.
And then what happens to you?
Then you wouldn't obtain a discharge.
Oh, okay. All right. So that means
But by the end, though, you might have, if you had a Chapter 13 case that lasted, let's say, 5 years, depending on what your planned payments were, you might have paid down the creditors significantly.
okay. And so early on, you mentioned about a trustee. Now, is that an individual that's assigned by the court to your case, or do you go out and get your own trustee, or how does the process work with regards to trustee?
So the debtor and the debtor's attorney have no control over who the trustee is. That's assigned. So in a Chapter 13, you have a Chapter 13 trustee, and we have a few of those in the Northern District. And then if it's a Chapter 7, then it's a 7 trustee who is usually a local bankruptcy attorney. In a Chapter 11, unless if it's a regular Chapter 11, then there is no trustee unless certain things occur that would warrant the appointment of a trustee. But if it's one of those Subchapter 5 cases that I was telling you about, then there is automatically a Subchapter 5 trustee, and that person's role is to help the debtor move along towards a plan.
So you indicated that the trustee is assigned. Who assigns the trustee? Is it the bankruptcy court judge, or is it the bankruptcy organizations, or how does that actually work?
So we have, there's a party involved in bankruptcy cases called the United States Trustee, and they're a branch, or they're an arm of the U.S. Department of Justice, and they basically oversee bankruptcy cases. And so the U.S. Trustee's office, they decide who these trustees can be, or who they are, basically, and there's a screening process for that.
And are these individuals compensated? I would imagine they're compensated.
Yes,
who
they are.
compensates them?
So they're compensated from the estate. If it's a Chapter 13 debtor, they get Chapter 13 trustee, then they get a certain percentage. If it's let's say a Subchapter 5 trustee, they get paid from the Chapter 11 estate to the extent there are assets there. And then Chapter 7 trustees, they get a statutory fee plus a certain percentage of assets that are collected.
Okay, so going back to the trustee, if a receiver is appointed in a case, the receiver actually reports to and works for the court, or the judge that appoints the trustee. In this case, with the receiver, in this case with the trustee, who's the trustee's responsibility is to whom?
So, for example, in a Chapter 7 case, the Chapter 7 trustee, that person's job is to maximize the recovery for the benefit of the unsecured creditors. So when we're talking about, let's say, a Chapter 7 case where there's a mortgage and there's a mortgagee, and then you have maybe some credit card claims and things like that. So the credit card claimant would be the unsecured creditors. There might be other types of unsecured creditors. So if the trustee can sell or administer assets for the benefit of the unsecured so that there's a certain percentage distribution to them, then that's what the goal would be. So in most cases, though, they're Chapter 7 cases, the majority of them are what's called no asset cases, where there's nothing available for the trustee to sell. So let's say there's a house that's worth $100,000 and there's a mortgage that's $90,000. Well, as I mentioned before, under state law, you have certain exemptions. So there's a homestead exemption, there might be, broker's fee and all of that. So in that case, a trustee would not sell the house because there would be no recovery for the unsecured creditors.
So in that case, the individual homeowner could keep the house in?
So that depends on what their plan is. So let's say they obtain a Chapter 7 discharge. They might just walk away and not pay because the note that's secured by the mortgage, they are no longer personally liable for that. So if they want to, they can walk away. Or they can pay.
So you indicated that the trustee works with the individuals and they make a determine, in terms of paying down the debt, who gets paid, so on and so forth, right?
In a Chapter 7 case, so in all cases, though, the creditors are paid according to priority. So they're, for example, priority tax creditors, and then there are other.
And then by priority, you mean someone who has filed their claim against you first, right?
So there are two things. So let's say I'm jumping around between chapters of the bankruptcy code. Let's say it's a Chapter 11 case. When I mentioned that you have to schedule all of your assets and liabilities, you also schedule all of your. When I say schedule, I mean you disclose them on the bankruptcy forms, which are called schedules. So included in those schedules are all of your creditors. And so you can schedule all of the creditors. Let's say it's a Chapter 11. And if you don't check the box that says that they're contingent, disputed, or unliquidated, then that is a claim that the creditor might not necessarily need to file a proof of claim. But whether they have a claim or not, so they would be paid according to priority. But you're right. If so, I'm getting a little technical here. Let's say the creditor, the debtor did schedule the creditor as disputed, and that creditor failed to file a proof of claim, then they wouldn't obtain distribution from the estate.
Well, it's understandable. This area of the law is somewhat confusing and technical, and but I mean, for the average person, if they have to file bankruptcy, so we're saying that either child filed bankruptcy under Chapter 7, right? Or
right.
13.
Or 11, correct, depending on how much debt they have. So 7, 11, or 13,
okay,
depending on what their goal is, and then you work backwards.
And by goal, what do we mean by goal? I mean,
if someone's goal is to maybe keep their house, then they might want to file a Chapter 13 or 11. If they have no equity in the house and that's not really a priority, or maybe they don't have a house and they just want to walk away from all the debts, and they might want to file a Chapter 7. The other big thing is whether they qualify for a Chapter 7. So not to get too technical, but in 2005, when the bankruptcy code changed, there were certain additional steps that a person needed to take in order to qualify for a Chapter 7. And that one of those things is called a Chapter 7 means test. And if they pass the means test and they're a consumer debtor, meaning that more than half of their debts are consumer related, not business related, then they can file a Chapter 7. But like I said, there's the policy that the government encourages repayment plans under 11s or 13s.
Okay. So if someone is able to satisfy paying off their debts while they're in bankruptcy, what happens then to their credit rating? I mean, are they able to go back out now into the world and try to purchase items on credit?
Surprisingly, yes. So their credit probably before filing would have been affected negatively from missed payments and that sort of thing. But surprisingly, let's say you obtain a Chapter 7 discharge. Companies will approach people almost right away about, credit cards and other loans, because these companies know that the individual can't file another Chapter 7 for several years. Okay. So they could, but that wouldn't be the goal. So you would want to, after obtaining the fresh start and obtaining the discharge, you'd want to make sure that circumstances don't require you to file another bankruptcy case, hopefully.
Okay, so, but I guess what I'm trying to get at is the bottom line is that you then do have a good credit rating, right? If you've satisfied your debts under the bankruptcy plan that was set up.
So your score doesn't necessarily increase right away. It would still take a while. And plus, the other thing is that bankruptcies are public. They're in the public record. It would be on your credit. And so it's not a private proceeding. That's the other thing that people need to know, is that everything that's filed is technically available to the public. And if they're concerned about privacy, that might be one reason that they might not want to file bankruptcy.
Okay. All right. Well, that was very fascinating, and I really appreciate all the information that you provided to our viewers regarding bankruptcy. Is there any particular number that anybody could call if they had any other questions regarding bankruptcy? This the bankruptcy court or as you mentioned, the trustee's office or anything of that nature?
So there, if you look in your district, each district has a bankruptcy court, and if you don't want to find an attorney, then there's a bankruptcy help desk that they can contact.
Okay, and that, for example, the Northern District, it would be downtown in Chicago
Right.
on Dearborn Street, correct?
Correct.
Okay. Well, Carol Sales, I really appreciate you being on the program. I hope that we were able to provide some enlightening information regarding the bankruptcy law. It is a complex area, and as Carol mentioned, if you have any questions, any concerns, to contact the bankruptcy court in the Northern District of Illinois. If you live in Cook County, if you're outside of Cook County, you might want to look at what district you belong to and then contact the bankruptcy office there. Again, it's been a pleasure to have Carol Sales on the show. And as I mentioned before, I am Justice Jesse Reyes, the president of the Diversity Scholarship Foundation. And this is, as I mentioned before, an ongoing conversation that we're having with members of the legal profession to highlight them, and then also to maybe be able to provide some information to the public with regards to some of the issues. And like in this program, we talked about the area of bankruptcy law. Try to do it within the short amount of time that we have on the program, but as all of you who have been watching probably realize, it's very complicated, and the best, I guess, would be to contact the experts and try to find some help along those areas. We just try to give some basic information regarding bankruptcy law again. This was the Diversity Scholarship Foundation's profiles in the law, and we look forward to having further conversations in the days and months ahead.
Thanks for having me.
You're welcome.